Thank you for tuning in. My name is Matthew Pospisil. I'm an associate here at Parnham Associates, and today we're going to be discussing driving while intoxicated. Now, driving while intoxicated, or DWI, is one of the most common offenses in the state of Texas. To be charged with the crime of DWI, the state has to prove that you were operating a motor vehicle while intoxicated. To break that down, the state's going to have to show that you were operating a motor vehicle. Now, a motor vehicle could be anything from a car to a boat or anything that has basically a motor inside of it that would power it forward. Now, the state also must show that you were operating that vehicle, which would be taking control of that vehicle and using it for its purpose. The state can prove that in a multitude of ways by showing that you were the one driving a car down the highway. Or let's say you just got done drinking, so you pull over into a parking lot to sleep it off. You leave the keys in the ignition, the car is running. That also could be construed as you operating that motor vehicle. Even though you weren't driving it at that time, you were still exerting control and using it for its purpose. They could construe that as operation. Now, the state also has to show that you were intoxicated. Under the Texas law, to be intoxicated would be to lose either the mental or physical abilities of yourself to operate that vehicle. The state can show this by drawing blood or taking your breath samples and showing that your blood alcohol concentrate was a 0.08 or higher. They can also do this by showing your field sobriety test, the SFSTs, which is this typical, like the walk-in turn or the one-legged stand that you typically will see in movies and TV. The state will try and show that you have lost the ability to control your mental and physical facilities by using these kind of observations. Now, in the state of Texas, we typically have two forms. You have a DUI, which is driving under the influence, as well as a DWI, which is driving while intoxicated. Now, typically the DUI pertains mostly to juveniles or those under the age of 21 who are not legal to drink. At that point in time, they are driving under the influence, and it doesn't really matter whether or not they are intoxicated for that aspect. It also would apply to those that are under the impairment of some type of alterant, like a drug type system going forward. Now, additionally, as you commonly have heard, the state can prove your blood alcohol concentrate by two forms, either a blow machine, like a breath test, or a blood draw. Now, under the state of Texas, we are all, by getting a driving license, agree basically to submit to either a breath test or a blood draw. You still have the right to refuse that going forward. What will typically happen though is that you will be arrested, they will take your license and issue you a temporary driving permit. If you refuse to give a breath sample or a blood draw, the state will be then forced to go forward to get a warrant to prove that going forward. Additionally, by refusing, your license has the opportunity to be suspended, and you'll have to go under what is called an administrative law review hearing, which is why it's important to have an attorney get involved immediately to protect your rights and fight for your license to prevent it from being suspended. Going forward, it's also imperative to have an attorney get involved immediately to assess the full authenticity of the test that's going to be administered, whether it be blood or breath. The longer delay in time is usually more favorable for the defendant going forward on the charge. The state's going to have to do some kind of calculations in math to try and prove what your blood alcohol content was at the time of driving, not later on. The state's going to try and do things called extrapolation, where they try and do this calculation to show what your blood alcohol either rose to in time or has declined to go back and show what it was at the time of driving. That's why it's important to have an attorney who is familiar with how to combat these allegations and go forward to further protect your rights. If you are convicted of a DWI, your punishment will range depending on a lot of different scenarios. The first one's going to be a simple Class B misdemeanor for your first DWI, if your blood alcohol concentrate is less than 0.15. The range of punishment for a Class B misdemeanor is up to 6 months in jail, as well as up to a $2,000 fine. If your blood alcohol concentrate is above a 0.15, you'll be charged with a Class A misdemeanor, which range of punishment is going to be up to 1 year in jail and up to a $4,000 fine. Additionally, if you have 3 or more DWIs, you'll be charged with a third-degree felony, with a range of punishment from 2 years up to 10 years in prison.